We now warmly welcome, up next, United States Senator Brian Schatz.
Hello, everyone. It is a real pleasure and an honor to be here with all of you today, and I want to thank the Future Society for having me. You know, you don't need to have me tell you what a pivotal moment this is for AI. You do this work day in and day out. You see firsthand how quickly this technology is evolving, the exciting possibilities and progress it stands to unlock, and the very real risks that need to be managed from the outset. When it comes to regulating AI, just about everyone agrees that the federal government of the United States has to play a central role. Where there isn't agreement is how we should do that. Given everything that's at stake, it's important that we get this right. Technology always moves faster than Congress. Just look at how much happened since the release of ChatGPT a year ago. And so it's impossible for lawmakers to foresee and enumerate every risk or bad outcome from a new technology, especially one as complex as AI. And that is the old model. Find a harm, ban it. Find a harm, ban it. Make a long list of statutory provisions that ban all of the things that we're afraid of or that we already saw happen that are terrifying to us. But it just doesn't work with a technology that moves that quickly. And so what we need are some basic common sense, future-proof principles that set clear rules of the road to help developers and companies innovate responsibly while also protecting consumers from potential harms. And for those principles to truly work, we need an expert government agency that's empowered to enforce them and establish case law over time. This approach has worked well before. When Congress passed the Communications Act in the 1930s, it put the Federal Communication Commission in charge of regulating the television industry. And while imperfect, the statute has stood the test of time, from the early days of the antenna TV to cable to now streaming. Similarly, the Communications Decency Act that passed in 1996 has governed the internet over successive waves of innovation and change, setting basic guardrails over what is and is not permissible online. Importantly, CDA did not outline every instance of malfeasance or misconduct that could occur online. That just wouldn't have been possible. And the same logic applies to AI. To use AI effectively and ethically, we need some ground rules for now and in the future. For instance, we need to know whether the content we encounter online is real or not, whether it was made by a human or made by a machine. That's a reasonable and straightforward expectation. But right now, that's not always the case. Whether we're watching TV, answering the phone, or scrolling through social media, we're increasingly confronted by fake images, doctored videos, and manipulated audio, all generated by AI. It's becoming harder and harder to believe our own eyes and our own ears. As AI-generated content becomes increasingly common, it needs to be labeled. It needs to be labeled. It's that simple. There are a lot of things. I mean, I've been attending Leader Schumer's AI forums, and they've been incredibly informative. And they have, I think, coalesced a bipartisan coalition for action. But a lot of these are long lead time items. A lot of these are hard. This one is not. People should know whether what they're looking for or looking at was generated by a person or by AI. Another area where we urgently need clear rules is around the use of data, because AI and data go hand in hand. AI models need data to learn and to function, and companies are already training their models on any and all existing data sets that they can get their hands on. But at a minimum, we should expect that the data isn't then used to harm the very people that provided it, whether that's facial recognition tools enabling discrimination at scale, or social media algorithms continuously boosting toxic content that fuels outrage and preys on people's vulnerabilities. There is nothing new or unreasonable about this, and a lot of especially government relations specialists, but also lawyers for big tech companies. This makes them terribly, terribly nervous. To establish a statutory principle, but not a specific set of prohibited and permitted acts, it makes lawyers nuts because they're not sure how the FCC or the FTC or a court may rule. But the only way to go forward is to establish the basic principles and let the expert agency run with it. And like I said, I'm not making this up from whole cloth. This is the way we have done tech policy for decades and decades and decades. And just because it makes the lobbyists nervous does not mean we shouldn't do it. There is a tendency in Washington to let the perfect be the enemy of the good when it comes to regulating tech. We've seen it happen over and over and over again in recent years, even in the face of glaring problems. But just as no one law will fix all of the internet's ills, no one law is going to be able to solve every issue in AI. And AI is advancing so quickly that we will need to respond to new developments as they come. Now, if you are using someone's data, you have to have a duty of care to the person whose data you are collecting. I understand that there are technical challenges with this, but again, this is not without precedent. When you provide confidential medical information to your doctor or clinician, when you provide confidential financial information to your tax preparer, when you provide confidential information to anyone with whom you work, your lawyer, they are permitted to collect the data. They are not permitted to weaponize that data against you. This is not an unreasonable principle. I see a lot of heads nodding, but I want you to know that we are very close to K Street, and they will not be nodding their heads. So please, if you wouldn't mind when this is over, have a drink, walk over to K Street, and talk to the people who are in the government relations space, because any lack of clarity, they try to kill. What they want is a very simple statute that they can hand to their chief technology officer and their chief legal officer and say, how do we keep doing what we're doing and work around this, code around this, and lawyer around this? And that is not going to get it done. So we need to take some common sense steps right now, even if they're sort of perceived as small. I don't think a duty of care is small. I don't think enabling a consumer of information to know whether or not they're looking at something that is generated by a human or by an algorithm, I don't think it's unreasonable to know those things. And I don't think it's unreasonable to say, if I'm putting my information on the internet, that I should be able to trust the corporation with that data. Not just not to disclose it, right? Not just to secure it, but to not weaponize it against me. I want to thank this forum for doing the kind of deep dive that is necessary to grapple with one of the great challenges of our generation. I am hopeful that we are kind of two minds. One is that we're going to have to do this over a series of decades, and some of these things we don't quite have the solution for, and yet there are some simple things that we need to do almost immediately, and conveniently, they are both my bills. Thank you very much.